Section 4b is registration of persons under the Uniform Securities Act. Since I spend so much time on the definitions portion of this section of the course, this section goes pretty quickly. If we already know it, I'm not going to beat you over the head and describe it to you 10 different times. I expect you remember what we've already discussed. As an agent, you can represent either a broker-dealer or an issuer. We discussed how no matter what you sell or how you sell it, you must register as an agent of a broker-dealer. But if you sell an exempt security or through an exempt transaction for the issuer, you need not register as an agent of the issuer unless you got paid a commission. It's also true that if you were selling a non-exempt security for the issuer, then you must register as an agent of the issuer. You know that agents must register in every state in which they do business. There is no de minimis rule. In order for an agent to register in another state, their broker-dealer must be registered there as well. To register in another state, the agent must fill out an application, pay a registration fee, and provide a consent to service of process form. If I was to say non-exempt security, what does that mean to you? We talked about that. Non-exempt security must be registered. So, would you agree if I said an unregistered non-exempt security is bad? That's the worst English I hope to use throughout the entire course. But would you agree with that? You wouldn't want to sell an unregistered, non-exempt security. Would you? No. Unless, isn't there always an unless? So, as an agent, you will get in trouble for selling an unregistered, non-exempt security. The only way you can legally sell it, unless it is sold through an exempt transaction. This is the hardest thing I do in the law section, in my opinion. If you sell an unregistered, non-exempt security through an exempt transaction, let me give you an example. Through a private placement, then you're doing the right thing and you will not get in trouble. A private placement under state law, you can make no more than 10 offers. What you're doing is you're selling an unregistered, non-exempt security, but it is perfectly legal to do so because that's what the private placement rule is all about. The only way you can legally sell an unregistered, non-exempt security is through an exempt transaction. Is anything exempt from the anti-fraud rules? No, of course not. If you were to violate state securities laws, you could be fined. You could lose your license. If you were to willfully violate state securities laws and there was a trial, if convicted, you could go to jail. The administrator can't sentence you to jail time, but you could incur jail time in addition to fines. You could be required to pay your client back money. You could have to return your commission. It's called disgorgement of commission if you're found guilty of violating state securities law. We'll talk more about that. You can't work within the securities industry for a broker-dealer unless you're registered as an agent. Unless you were purely clerical, then of course clerical staff, they're not agents. Simply passing this examination does not constitute registration in a state. So the Series 65 and 66 exams themselves can be taken without a sponsor on what's called a U-10 form. But even if I was to go and take and pass the test without working for my Series 65 or 66, I have to work for an IA. Unless I work for an IA, I won't be properly licensed. So I could pass the test, but in order to engage in this industry, I have to be granted registration by the administrator. So simply passing the test does not constitute registration. Changes in employment. If an agent leaves the broker-dealer, the old employer, the agent, and the new broker-dealer would all be involved in notifying the state securities administrator. So all of these three parties would be involved in notification as far as changes in employment. So when you leave a firm, what's filed is called a U5 form, and then you would reapply at your new firm. You'd file a new U4. You can't just transfer over your registration. Something that's interesting to know as well, not necessarily for the test, but once you U5, you have 2 years to reapply without having to retest. We know the definition of broker-dealer, broker acting for their customers, dealer acting for themselves. We know agents are not broker-dealers. We know that issuers are not broker-dealers. We know banks are not broker-dealers. We know that if the broker-dealer is from outside the state, they can do business in the state without registration with as many institutional clients as they like. But the minute they have a public customer, both the agent and the broker-dealer must be registered in this state. If the broker-dealer should reorganize, the successor firm is allowed to register as a successor firm, and the first year they don't have to pay a filing fee. They would be allowed to use the unexpired portion of the previous filing fee that had been paid. Firm registration. So this is Form BD to create the broker-dealer. At the time a broker-dealer is registered, anyone who is a partner, officer, or director of the broker-dealer is automatically registered as an agent if that person acts in the capacity of an agent and not otherwise. So if you were a silent partner at a broker-dealer, then you would not be registered as an agent because you don't act in such a capacity. We know that broker-dealers must file consent to service of process in every state in which they're registered. Other information found on Form BD includes the form and place of business organization, the proposed method of doing business, qualifications in business history, history of injunctions, conviction of any felony or conviction of any misdemeanor involving any aspect of the securities business, financial condition and history. That's all on Form BD for the firm. Investment advisors and investment advisor representatives cannot conduct business in this state unless they are registered in this state, or they're allowed to do business with as many institutional clients as they would like without registration. And there is a state de minimis rule. An IA and IAR is allowed to do business in another state, one in which they are not registered, with up to 5 public clients. So fewer than 6, state de minimis rule. If they have 6 clients, then they must register. Both the IAR and the IA must register in that state. So when we use the term investment advisor representative, that means you. IA is your firm. Financial planners are included within the definition of investment advisor. We know that any person that works at an IA is included within the definition of IAR if they are a partner, officer, or director, or any other individual employed by the IA, with the exception of clerical and administrative personnel, as well as trainers. If the IAR leaves the firm, the rules are different. So this rule, as far as if an agent left a broker-dealer, the new broker-dealer, and the agent all were responsible for notifying the administrator. If the IAR leaves the firm, though, it depends who notifies the administrator. So here's the IA, and the IA could be registered either at the state or federal level, depending. So the IA is either registered with the SEC or registered with the state. So if the IAR leaves the firm and the IA is state registered, the question is, who notifies the state? If the IAR works for a state-registered investment advisor, then it's the firm that notifies the administrator. If the IAR works for a state-registered investment advisor. If, however, the IAR works for an IA that is registered at the federal level with the SEC, then it's the IAR's job to notify the state if they should leave. So you have to be really careful on this question. It depends. When the IAR leaves the firm, who notifies the administrator depends upon where is the firm registered. If the firm is registered at the federal level, the IAR is always registered at the state. The IAR is can only be registered at the state. So the IAR works for a federally covered investment advisor. They decide to leave the firm, then it's the IAR's job to notify the state. We talked about when does the firm have to register federally, when does the firm have to register at the state level. Depends upon if they manage a mutual fund, then they're always federally registered. And then the other determining factor was the size of assets under management. So let's say the question says the firm has $150 million in assets under management. Where would the firm register? Federally. What if they had $20 million in assets under management? State. So watch for the rule change in the real world. Net capital requirements, how much cash and readily convertible into cash the firm must have on hand. If the firm has custody of a client's money and or securities, the net capital requirement is $35,000. A person's effective date of registration. Unless you're denied registration by the administrator, your registration shall become effective within 30 days after the registration application has been filed with the state or sooner, at the discretion of the state securities administrator. Every person's registration, so this is broker-dealers, agents, IAs, and IARs, all of their registrations expire at the end of the year, December 31st. They need to be renewed. So if you get your license December 15th, when does your license expire? December 31st. They love that on the test. Your withdrawal from registration will be effective within 30 days or sooner at the discretion of the state securities administrator. Your withdrawal from registration may be denied or delayed at least if they're pending investigation into any of your actions. Reasons why the administrator may deny, suspend, or revoke a person's registration. If it's in the public interest to deny, suspend, or revoke the registration and a law has been violated, such as some of these that follow, then it is okay for the administrator to deny, suspend, or revoke your registration. You have to be given the opportunity for a hearing, however. You can't be licensed in the industry and then get a letter that says, oh, hey, Susie, we took away your license last Wednesday, but we're just getting around to telling you now. No. You'd have a hearing, the opportunity to defend yourself. They have to give you that. So these are some offenses that you would never do. filing an incomplete, false, or misleading application for registration, willfully violating any provision of the Uniform Securities Act, being convicted of a misdemeanor involving any aspect of the securities business, or being convicted of any felony within the past 10 years. So if you had a misdemeanor 8 years ago, but it was not securities related, it will not affect your ability to be registered. If you had a securities related misdemeanor in the previous 10 years, then it will affect your ability to be registered. If you had a felony 9 years ago, it will affect your ability to be registered. Your felony was 12 years ago, you're fine. So weird. Always disclose everything. You don't want to hide anything. Always disclose everything. So be careful on that question. They try to trick you. Being enjoined from engaging in the securities business by court of law, or being subject to an order of the administrator denying, suspending, or revoking your registration. Engaging in dishonest or unethical securities practices. That's bad. Being or becoming insolvent. Being not qualified on the basis of training, experience, or knowledge. Being in a supervisory position and failing to supervise registered employees. You will not lose your license for failure to supervise your clerical staff. So if you don't want to supervise someone, don't supervise your clerical staff, but you must supervise your registered staff. Failing to pay application filing fees. Experience is a consideration, but lack of experience cannot be the sole reason why they deny your registration. You have to start somewhere. So passing these tests, that's enough experience to get licensed. The longer you're in the industry, the more experience you'll have. Obviously, the more complex transactions you'll feel comfortable engaging in. I told you that you always must be given the opportunity for a hearing. Although the administrator may issue a stop cease and desist order telling you to please not do that illegal thing that they just heard you were about to do, they can do that without a hearing, but they cannot take away your license without a hearing first. If your firm loses their license, you will lose yours, meaning yours would be U5'd and you'd have to find a new firm and reapply. If you lose your license, does your firm lose theirs? Generally speaking, no. If the administrator finds that you are not engaged in the securities business, you cannot be licensed. This license is not like insurance that you can kind of keep it forever even if you don't do it. If you're not engaged in this industry, you cannot be licensed. The administrator can also cancel your registration if they can't find you because you disappeared. That might be kind of fun. Sales and advertising material may be required to be filed unless the security is exempt or being sold through an exempt transaction. Sales and advertising material cannot be false or misleading. Of course not. Records and record keeping. Broker-dealers and investment advisors, so this is the firm level, must keep records. Broker-dealers must keep the records for 3 years. Investment advisors must keep the records for 5. Both of them must keep them readily accessible for 2 years. That means in their office, readily accessible for 2 years from the date of the record. The firm must file whatever financial reports the administrator asks for. So income statement, balance sheet, statement of net capital must be filed. Not you, but your firm. Amendments to records. Anytime any information on your U4 form should become inaccurate, you must file an amendment to the records promptly. There's no period of time that you're allowed to wait. Amendments to records must be made promptly. That concludes our discussion for registration of persons under the Uniform Securities Act. Practice this section quiz. Good luck.